We've got some very, very big news coming out of Donald Trump right now. He has just announced his intention to sue Facebook, Twitter, and Google as a massive class action suit on behalf of everybody who has been canceled. Let's talk about it very quickly. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, hit like, subscribe, share, turn on your notifications, all of that good stuff. This is straight in from disclose.tv on Twitter. And they say Trump to announce a class action lawsuit today against Twitter CEO Jack Dorsey, Facebook CEO Mark Zuckerberg on behalf of people who have been canceled by social media. And then they have confirmed it. Trump is to file a major lawsuit against Twitter, Facebook, Google, and their CEOs over the censorship of American citizens. So this is very big news. There are people who have been asking what Donald Trump is going to do in this, and if he is the class representative, that could be some big stuff, because Donald Trump definitely has standing if there is a claim to make. But that is ultimately the question that we have to ask about social media. There are various sort of ideas and theories about how to approach these social media organizations when it comes to cancellation and cancel culture. These cancellations have very, very big impacts on how people do things, how they conduct their lives, and how they conduct their businesses. These are not just simple matters of, oh, well, sorry, you just can't do that thing anymore. And there are real business and personal implications involved in all of this, including rights to data that you no longer have after you're canceled, direct messages, contacts, all of that stuff. Where is the line on all of these things that exist in this realm of social media that has become a part of our daily lives? The big barrier to all this, of course, is a couple-fold. One is the freedom of contract. Do private companies that become monolithic social media networks have the freedom to contract or to not contract with an individual based on any particular thing that is not protected by something like Title VII of the Civil Rights Code, a race-based discrimination or something of the sort? If they have a freedom of contract and a freedom to reject those contracts with impunity, then this suit is destined to fail. But we don't actually know that they have that. That's just a meme and a mantra that has been bandied about on social media whenever someone gets canceled is, well, they don't have to do business with you. But the reality is they might have to do business with you because of how they have established their companies. We have open platforms and open public accommodations all over this country that do not have the right to just foreclose business with someone without a particularly good reason. So then the next questions are their terms of services particularly good reasons? Are their terms of services actual terms of services? Terms of services are contracts, and that makes them binding agreements, not only from you, but also from the company back to you. But do they feel binding? They don't really feel binding to me. The idea of these terms of service adhesion contracts is that they are basically an open offer from the company. If you come and follow these rules, we will provide you with the service that we say we will provide you with. Now, if you go and you follow those rules, and then they decide that you broke a rule, why are they the only person who gets to decide whether or not you broke a rule, especially when those rules are vague and ambiguous? It kind of makes the contract look illusory. If the contract is illusory, then they can't actually impose terms of service rules on you in the first place because there's not actually a contract. So then, if there isn't actually a contract that you're giving up some of your ability to conduct business based on an agreed set of rules because there's no agreement, they may not have that, and it may be more like a public accommodation or a common carrier service. Then, of course, the next question is, are they a common carrier or something akin to it? These are the types of questions that are going to be asked in that lawsuit. I would hope, if it's not just a gimmick or a stunt or a media play, and it's a genuine lawsuit with very good lawyers involved, we should see some novel theories and some novel ideas. And the ultimate barrier here is, of course, Section 230, which ostensibly insulates any online platform from civil liability based on actions that involve moderation. That's a very high level overview of Section 230. That's how it's been applied. That's not necessarily how it's supposed to be applied. And if this case were to progress beyond just the initial stages, we may see some decisions about it. I will be watching. If you want to watch with me, make sure you go ahead and subscribe to this channel and follow along. You can also follow me on Twitter or check out my locals, rekietalaw.locals.com. If you want to have access to all of my content that I post, Locals is the place to do it. But let's see what Teflon Don can do to the major social media companies. Until next time, thanks for watching. Peace. Peace.